Welcome back to our feature on new laws from the 2019 Utah legislative session. There were a lot of changes that the legislature made to Utah family law in 2019, and we're going to tell you about all of them, just not all at once. The legislature amended Utah Code Section 30-3-34. Now that code section provides what a non-custodial parent will be awarded according to the statutory minimum parent time schedule. In other words, that parent will get that minimum schedule unless it can be established by a preponderance of the evidence that more or less parent time should be awarded. In the 2019 legislative session, the legislature added some new criteria for determining whether parent time should be greater or less than the statutory minimums. So what are those new criteria? One of them is whether, quote, parent time would endanger the child's mental health, close quote. Now, until 2019, the criteria was simply whether parent time would endanger the child's physical health or significantly impair the child's emotional development. The amended code section does neither define what mental health is nor what constitutes endangerment of a child's mental health. I'm sure that the appellate courts just love that. And there's more. Additional new criteria include, quote, evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, or a parent, or a household member of the parent, close quote. And, quote, a credible allegation of child abuse has been made, close quote. While I think we can all agree on a sensible definition of what domestic violence is, and what neglect is, physical abuse is, and sexual abuse is, the legislature did not define what emotional abuse is or means. Now, I'm going to go out on a limb here and predict that emotional abuse will now be one of the most popular stated bases for arguing over child custody and parent time. Why? Because emotional abuse is all but impossible to identify or quantify objectively. Human beings are suckers for sad stories, and judges and court commissioners are human beings after all. So go ahead, accuse your spouse of emotional abuse, whatever that means. At this point, it can mean whatever you want. Adding emotional abuse as a criteria for determining child custody and parent time is an invitation to abuse the very term. Again, I'm sure the appellate courts are both impressed with this feat of statutory draftsmanship and thrilled at the prospects for appellate review in the years to come. Here's the link to Section 30-3-34. We hope you find this interesting and useful. If you have other Utah family law questions, you can email them or text message them to us, and we'll be happy to answer them. Just email us at utahfamilylawtv@gmail.com or text us at 801-450-0183.